Okay, well, welcome everybody in the webcast audience. I'm Terry Magady, chair of the Elder Law section of the Trust and Estates section, Elder Law Committee of the Trust and Estates section, and I happen to be our speaker today too. But the first thing I'd like to do before anything, of course, is to show gratitude to our sponsors, because they are really the folks that help keep these programs going. And the first sponsor is the Sanborn team, and it should show on the screen there, Leslie. If you can put their little ad up. Nope, that's well, we'll go right to, there's the Sanborn team. Okay, thank you, Nancy Sanborn and the Sanborn team. Real estate brokers who specialize in our field that we deal with, probate, trust, conservatorships, sales for older people. Thank you, Nancy and the Sanborn team. And our next sponsor, it's a pleasure. I can introduce her because she is here in person, Orit Gadish. Thank you, Orit, and I'll turn the floor over to you.
Thank you, Terry. Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate. We specialize in representing trustees, administrators, executors in the sale of commercial and residential real estate. If you'd like to sell a property in as-is condition, we can help you get the property ready for market with a cleanup if needed. If you'd like to consider adding value prior to selling the property, we can support you with that as well. Whether it's a partial or complete renovation, we first conduct our due diligence to determine the most appropriate value-add solution. And then we execute with no cost to the seller until escrow has closed. We also offer staging services and have a designer on our team to ensure the properties we're selling are appealing to buyers, and we're drawing on their emotions to allow them to offer top prices. We're not a cookie cutter renovator. Feel free to reach out to me via text or cell. My number is in the chat box, and enjoy our program. Back to you, Terry.
Thanks, Orit. Our next sponsor, which should show on the screen now, is Marcine Klein from Glen Oaks Escrow. And as with all of our sponsors, her services are tailored to our particular space that we operate in. Escrows for probates and trusts and conservatorships. And she does a great job. And thank you, Marcine, for being our sponsor. Our next sponsor is California Title Company, and they are also a title company that specializes in probates, trusts, and conservatorships. Thank you very much for being our sponsor, California Title Company. And finally, our newest sponsor, Manufacturers Bank, an institution who also works, you could see from the ad, works and gears itself to our areas: conservatorships, trusts, older people, probates. Thank you, Manufacturers Bank, for joining our sponsors here. And now we'll move on to our, but right before our program, before we move on to our program, let me let you know what's going on next here. On July 22nd, Karen Hess from Jewish Family Services will be speaking about, I'll use the acronym, ALW. And if you don't know what ALW is, show up on July 22nd. It's the assisted living waiver. We've never had anybody speak about that niche program, and it's really a great program. And Karen's been doing the program for years with JFS. So that's July 22nd. Then on August 25th, our speaker is going to be Brittany Trujillo, and she's with Public Consulting Group. And they're a national consulting group that has been hired by many government agencies all over, including, I'm pretty sure, some in California, because that's how I found her, who are implementing something called the final rule, which keeps getting postponed year after year, but now it's less than a year away. And if you don't know what that is, and you deal in the elder world, if you deal in world of people with disabilities, show up on August 25th, because it's a big thing on the provider side, this final rule. And now we'll get on with our program today. Okay. I can't think of one time. I've been doing this for many years, chairing our group. And the only other time I spoke is as the speaker, is when we had an emergency situation with the pandemic and certain things need to be addressed. But it just so happens that July 1, which is around the corner, there's a major game-changing rule that's going to happen that's a bullseye in the industry it's my expertise. So I'd like to share it with you. And then we'll talk about other things related to, I called it the program, identifying fiduciary scenarios that demand high-level Medi-Cal benefits planning. But we're going to start off with explaining this new rule, which is a total game changer in the industry. And we don't have slides, but you can just follow along. I've got an outline if you want to know the direction I'm going for the program. And I'll try to leave time toward the end, 15 minutes, 10 minutes, whenever, depending on how many questions we have in the box below, so that I could have some give and take with those of you who are listening in. So I'm going to start off with something personal because I find I'm interested if I hear something personal about a speaker, because it connects me to the subject matter more. So question is, how did I get into the business? So in a different time, I was actually a real estate attorney. I actually chaired our real estate committee. Can you believe that, Orit? It was someone I could see. So someone, it was a long time ago, pre-Tesla, it was a very long time ago. But then I transitioned out of real estate, even though I enjoy real estate still, so into elder law and disabilities law. So why did I do that? So I have 3 kids. They're adults actually now, but three kids, and my oldest has Down syndrome. She's Danielle, who's 31, and I have two boys too. And so she had Down syndrome and has Down syndrome. And so after she was born, I made a kind of career change into the field of disabilities, which led into elder law. And the very, I'll just say, cool thing about that is that now not only do I have a daughter with Down syndrome, but I have a son-in-law for 8 years with Down syndrome, because Danielle has been married and living on her own with a young man, her husband, who also has Down syndrome. And that's a story for another time. And but that's how I got into this business of from real estate over to disabilities, elder law, government benefits. And now the next question is, why has Medi-Cal become so important? The key reason is it's not a program for poor people any longer. I mean, it's been that way for a long time. It's designed for poor people, but for a long time, that has not been the case. And now it is really not the case, and it's really becoming not the case. And it funds a lot of long-term care in our state. So it's relevant for many people. When you have lots of money, it's relevant too. Or if you're a fiduciary or an attorney for people who have money, it's relevant. And now, why are other benefits also so important? Because you can't ignore, there are other, I'll call them powerful benefits out there. Words you should know besides Medi-Cal. There's the affordable housing, it's really privately subsidized housing for, there's set aside units for all these construction apartments that are going up all over that go by basically Section 8 rules. That's a very powerful program, with its own set of rules that are very different from Medi-Cal rules. And then maybe I would call it the most powerful benefit at all, and that it was supportive living services, SLS, also independent living services is another offshoot of it, from regional center for people who are regional center clients. And another brand new word that not brand, relatively new word, in a program that opened up for everybody also in 2022, which is self-determination. If you don't know about those and you're dealing in this field, you should know about them because they're big, they're game changers. In addition to the changes in Medi-Cal. I mean, it's the only place that people can actually get potentially payment for market rate medical professionals in the mental health field, among other things. It's an incredible program. The next thing I mentioned in the introduction is I like to reframe this because the world of government benefits, and I called it, quote, the emerging asset class. It's a little snazzier to think of yourself as like an investment banker for an asset class, but that's really what it is now. I many times recently, due to now particularly the stock market, due to inflation, due to the high cost of care, fiduciaries who I advise, that's my typical client, families and fiduciaries, even when people have lots of assets and lots of money, all of a sudden you see how it's eating away at the assets with people living long, care costs going up significantly, and uncertainty with inflation in the stock market. So it's really something, all of a sudden, people with portfolios that are large in fiduciary portfolios should be looking at because it produces money for people. And then I use an outline Zoom, I guess, to make it relevant for today. But when you look at the situations, you really have to zoom back and see everything. It's just not narrow benefits. You have to see the whole circumstances of the family. And each government benefit or other benefit too is quite complicated with it's got its own rules, own negative ramifications, own positive ramifications. So it can't be it's not simply, do a trust, protect government benefits, and that's it. There's much more to that. And then just to talk about it in terms of, the most oft-used tool historically that people use in the industry, people use, for inheritances and for personal injury settlements, first-party special needs trust. Someone has to really understand the disadvantages of first-party special needs trust. And we'll get into that when we talk about some examples. And they're fine in certain circumstances, but you have to refine how they're used. And you'll get what I'm talking about when we get to examples. Now for these new rules, okay? I put in the documents that you have there for the materials, what's called the all-county letter that spells it out. Because I think you may need to show it or forward it to people because people don't believe it. And it's a statute added, Welfare Institutions Code. And unlike most things in the world of Medi-Cal, it's actually pretty simple. Other things in Medi-Cal are very hard to get a handle on because you have a source here, there, all over, and it's hard to figure out everything. That's the barrier to entry and understanding the field. But this one is easy. The rule's right there. And next, before I say what it is, it only applies to what they call non-Magady Medi-Cal. The Obamacare changed Medi-Cal a lot, and it opened up Medi-Cal as a program in certain circumstances for people based on income only, not assets, but people who don't have other insurance, including Medicare. But this is for other people, not the ones on Magady or Obamacare Medi-Cal. And for those people, here it is, July 1, the asset limit that you think about in common parlance of $2,000, it goes up to $130,000. And then $65,000 for every other member of your household. not your, it's specific definitions of household. It's MFBU, it's called in the Medi-Cal world. You think it really, it's husband, wife, usually minor child or children 21 or under 21 who live at home. It's kind of the anti-empty nesting rule, I think, because it pays to get your 20-year-old to move back home with you. So 130,000 for a person, 65,000 for every person after that in your household. And then January 1, 2024, the asset limit is scheduled to disappear. Now, before 2024, we still have all the other exclusions, which there are many assets that are not counted, which we'll touch on, but those all stay the same. But January 1, 2024, it's supposed to be scheduled all to be eliminated because it says it can be eliminated no sooner than. And now my question is, can you count on January 1, 2024 for the asset test to be eliminated? Well, I'll go out on the limb. I don't know. So we don't know what's actually going to happen. A lot of things can happen before then, but that's where it's headed, to take away asset limits in their entirety. And the next, obviously, the obvious consequence of it all will be many more people in the state of California will be on the Medi-Cal program, particularly for long-term care. And I didn't list what I'm going to mention next because it's not a fact, but it's just what I see. If I look down in the future and I think about advising families, is its relationship really to thinking about Medicare, not Medi-Cal, because after Obamacare went through and they had no more pre-existing conditions, and it used to be there were disabled people and you wanted to get them on the Medicare program in a variety of ways because you can't, Medi-Cal was not so great, and you wanted an opportunity to get better insurance for the person, so you thought about Medicare, and you stopped thinking about it as much when Obamacare said, you can go out, no pre-existing conditions, just go out and get your Blue Shield PPO policy. Now, what I think is that, so much of the insurance industry, it's going more and more into a kind of an HMO umbrella for coverage, where even with individual plans, it's in some aspects that way. So that all of a sudden Medicare becomes important again, because Medicare and supplemental insurance, if you can get into that and plan for that, which you can plan and have strategies for that, is really, at least for now, a great payor, relatively speaking, for physicians. So you want that if you want the best for whoever you're thinking about it. So all of a sudden, just thinking about Medicare becomes more important. What are some immediate ramifications of this thing? So one, this is obvious, underline, exclamation point, make it all bold. If any of you are fiduciaries in the participants out there, if any of you advise fiduciaries, you must have some beneficiaries, clients, conservatees that are in a skilled nursing facility. If you let this time go by now, and that person has, you'd say, $130,000 in July, and you say, oh, we've never applied for Medi-Cal because they have $130,000, well, you better change that, because you should be applying, subject to all sorts of other things related, pros, cons, ramifications. You should all of a sudden look at Medi-Cal. And if you don't, it's problematic. All of a sudden, too, I mentioned these are the immediate ramifications. Other programs that are just, the producers for long-term care, mentioned in-home supportive services, all the in-home community-based waiver programs, ALW, assisted living, which you'll hear about, MSSP, those programs, all of a sudden, for the people that you have in your clientele who you're helping, all of those become possibilities now when you think of the asset limit increases. So that's the immediate ramification. The second ramification, and this is more into planning and decision making. And good decisions, it always takes, you're balancing things, you're doing things carefully, not, it's rarely so simple because people aren't so simple. But it's this new asset limit is going to weigh in on the decision making. So often, so many times it's weighing in, but so in the obvious one, there's more flexibility for the person who is disabled, often maybe in a physical disability, who's looking for Medi-Cal, but doesn't want to do all the things that go into getting on Medi-Cal. A person wants to keep control of assets, doesn't want just somebody, a trustee, who they don't know to be managing things for them. I come across that all the time. Well, now they have to think, I hang on maybe 130,000 limit and 65,000 per person extra. We'll do it. Maybe I can wait till January 1, 2024. It's a good shot at that happening. Do I really want to tie things up with when I've got a shot at controlling my own ship instead of giving it to somebody else to steer so I can get on Medi-Cal, which may be important for me. And also in planning, it's an additional disincentive for a first-party special needs trust, which has, benefits. We'll talk about it shortly, but big downside, which is you're giving a recovery right to the state of California that's not there otherwise. And it's going to have some ramifications for third-party special needs trusts, even though a lot of the time, those trusts, even if you don't think about government benefits, are a good idea for someone who really can't manage their affairs. But this is one more factor that you have to think about. And it's really just another quiver in a big portfolio of tools that you have. And when you couple it with the change that happened in January 1, 2017, which is basically the state of California recovery was knocked out, except for probates and first-party special needs trusts. And I don't think quiver is the right. It's more like a torpedo launcher you have. You have a lot of torpedoes in order to get the target for your person, which is to get the person government benefits. And by the way, this may be, I probably should have said this at the beginning, but my goal, I'm not creating public policy. I've been doing these talks for many, many years, and often somebody says something about this, why should this be the case? Why should that be the case? The public policy is not my purview now. So my purview is I'm a zealous advocate trying to help a fiduciary who's trying to help a beneficiary or trying to help a family. So the state of California is not my direct concern, and the federal government's not my direct concern. My concern, what I'm hired to do, is help a family member. So just wanted to mention that. Now, remember, there are many other not counted assets. I mean, this is a whole talk into itself, but just to list things so people have a sense. They're exempt IRAs. Those are your spouse's IRAs. There's your own IRA. It's called unavailable if you elect even a minimal distribution. Community spouse resource allowance. Home, even if it's a multifamily home. Unavailable extra real estate. Third-party trusts. There are so many. The list is quite long of other assets. But with this, now you have the $130,000 exemption. Also, in terms of gifting, used to be, we still have something called serial gifting. Again, another, just one more, you could have a whole seminar on that. But now, if you gift under an exemption amount, $130,000, there's no gifting penalty for that, which only applies anyway to skilled nursing benefits, not home-based benefits. But the important thing to think about, even when the asset rules go away, it doesn't take away the planning, really. It makes it easier, but you've still got income issues. So all of a sudden you're doing income planning because the income can knock you out for Medi-Cal anyway. So you're thinking about things with income, which are in-home waivers. I mentioned a few of them here, Cal-Able program for people 26 and under, Medi-Cal working disabled program, loans on income producing properties. We're going to probably be getting into more. In fact, I was just speaking to some folks at Department of Health Services about this, more irrevocable trusts that you can control income from, standard income, small reductions, health, vision, dental policies. So the play is moving away from assets then, but toward income planning. Let's get into some real live examples, because that's interesting. And these are situations I used one. Let's see, we'll start with the one using Magady, I don't even know how to pronounce it, Maggie or Maggie, Medi-Cal, and avoiding the trap of first-party special needs trust when it's the routine procedure for someone under 65 and no Medicare. So this is a real live example. And I'll say the word malpractice at the beginning that gets people's attention. If someone in this situation did a first-party special needs trust, which I think that would be most people, maybe even more than most, I consider it malpractice. Why? I look at this situation, I hear the things I think about. What type of Medi-Cal does the person have? What type of Medi-Cal is the person going to have in the future? Is there a dependent, an heir, a child? Can you avoid Medicare? And that means in this situation, we purposely wanted to avoid Medicare because I wanted to get on the Obamacare Medi-Cal, or I wanted to keep on that. And then again, for this one, you shift to income thinking, but income thinking for Obamacare Medi-Cal is different than the traditional Medicare. Okay, what's the example? All of these are sad, by the way. It's a sad, I mean, much of my work, if the underlying situations are sad. So without saying how it happened, this particular person, there were some things that happened to the people. And the result is you have a person in her 40s who's really still in kind of a vegetative state. It's got to be 2-3 years. It's been a few years already. But the person got a personal injury settlement coming in about $2 million. And she was in her, I think, 40s, but she has little kids. So many people from the get-go would say, well, that's a special needs trust, isn't it? No, it's not. So in this particular case, the court-appointed attorney brought me in, because it's my expertise, and we also had a private fiduciary came in. What did we do instead of put $2 million in a first-party special needs trust that would just result in the person continuing to get Medi-Cal because she's in acute care, subacute care from the get-go now, and nothing left for her kids? That would be awful. Okay, she actually had one kid who's I think 19, but two minors. Sad situation, but the result was tremendous. Instead of having a special needs trust, we had just put the money in a regular trust that was created by the court through substitute judgment. Regular trust. Why regular trust? Because I don't want probate. Probate means recovery. What do you do with all that money in regular trust? Well, if you invest the money in dividends, investment vehicles that produce state and federal tax-free dividends, they have to be dividends, not interest, then the income is not counted for Obamacare Medi-Cal. And you just have to be careful about gains on sale. So we did that, and the result is the money is there, it's being used. She continues to be on Medi-Cal, but because the money is in a revocable trust, there will be no state recovery period. And in this case, I think I would probably, even with the laws the way the changes are, I would probably keep it that way. And the only thing I would to be wary of is, well, whenever this person turns 65, then I maybe would switch it to something else. But I wouldn't I could do planning in this case with an irrevocable trust, but I like the revocable model better. So I probably would do the same thing there. And if anyone did a special needs trust for this first party, it would be awful because the person would be on Medi-Cal and these little kids would get nothing. So next example, another nice, again, it's sad, but this one she had Medicare. This is on considering an alternative first party special needs trust when it's not an alternative to it, when it's not possible. 65 and over with Medicare. On this one, I wanted the situation, I'm going to blur it a little so the facts aren't, so apparent to people to identify anyone. But the person in this situation, it was court supervised. I wanted not to have a special needs trust as a possibility. I wanted the person to just be over 65, which was done. And then with this money, this is also a sad situation, but this person had adult children who were very tight family, single, a woman, 40s again, somewhere around the same amount of money, a couple $1 million coming in. What do you do, Terry? You can't go back to that Obamacare Medi-Cal, and this, 2024 is not here yet. What do you do? In this particular case, we got the money. The family wanted to live together. It was a close, culturally speaking, from a particular culture that everybody lives together. They wanted to get mom home, even though she was in a almost subacute condition. And it was all court supervised, court everything, okayed. Go in, buy a home, which is an exempt asset, but multifamily, in this case, duplex, and kids part in one unit, somebody with mom in the other unit, and that's an exempt asset. What do you do for cash? That's a legitimate concern. Well, concurrently, if you get a reverse mortgage on it, you can borrow out the money. You can pay for escrow and property taxes and take care of that, and then borrow out extra money as you need it. And it was a nice plan. And unfortunately, we were right into it, and the person passed away. But for the kids, for her, she would have been happy because, again, there was no recovery for her kids. And she stayed on Medi-Cal due to the timing, it was right around the time it was during the pandemic where they curtailed taking people off the Medi-Cal program, simply put. Another one, this is one where this is on the list, it's number 7. I ask questions again, what do you do instead of the first party special needs trust? Questions I asked here, is it's husband and wife, is it a solid marriage? Does the person in the skilled nursing facility, in this case, have capacity? Is that person represented by counsel? All those things were the case here. Is this traditional long-term Medi-Cal? Answer is yes. In this particular case, I went in and we got, I think we had a few $100,000 already, went and got a court order for the spouse to keep the few $100,000, and we had a home. And then the settlement came in, roughly a little over $1 million. But after the community spouse resource allowance, that $300,000 was established, the income coming in was just transferred from the person in the skilled nursing to the person outside the skilled nursing facility, and it's no longer counted after that. Because once you establish that $300,000, that was the amount there, someone could inherit $1 billion. Someone could get $1 billion judgment. It's out of the picture. I usually compared it to that famous painting with the husband and wife farmers. I think they're husband and wife, American Gothic, where at first they look at you together, but once you get that community spouse resource allowance established, you're separate, and then money can come in. And there's no transfer penalty between husband and wife. So that worked out very nicely for the family. We did other planning, and that alternative, again, would have been a first party special needs trust with recovery. Who needs that, for a spouse? Good marriage representation. The next one which is number 8 on the list, is nice because it starts to use, then now you can see how you can really use a first party special needs trust, because this situation had quite a few different assets in it. We had more than one home. This is a conservatorship again. We had more than one home here, home there. We had Iras. We had a lot of income coming in from disability income. And we had someone under 65, so I could establish a special needs trust. So you look at each one of these assets, what can you do with them? So the Iras, as I mentioned, they're not counted, even though somebody in their 40s, this case, person was 50s, but is not taking distributions, but used to elect any distribution. It elect $25 and makes it not counted. You have to elect it, it should come out, you should get it every year, makes it go from a counted asset to an unavailable asset. Then those were the Iras. The second home, one of the homes was the one she went back to live in. The second home, we actually put on the market to sell, and we got some, and so while we're selling it, it wasn't counted for Medi-Cal. And for those net proceeds, wasn't that much there, a couple $100,000. We did put that in the special needs trust with recovery, because the goal was here to use that money to supplement what Medi-Cal was going to pay for her at home. So the second home, special needs trust, sold it. First home is the one she went back to. And because she was in a skilled nursing facility, we were able to use an in-home waiver to get the care back to the home and with significant money back home. People should be aware of this in-home waiver. So, but it's a very nice thing to get significant care at home, not in-home supportive services. It's over and above that program. So that was good too. But what do you do with this income coming in? You have disability income. Fortunately, it was assignable, and that went to a special needs trust too. So we have the couple $100,000, we have the assignable income from the disability income that supplemented the care at home, where Medi-Cal picked up most of the care at home. We had that first home I was talking about, and immediately, because this was like, I think right at the beginning of 2017, we did substitute judgment to put that first home into a revocable trust. It was just held in her name alone, because then you could avoid recovery on it. And there you go. We got care paid for at home for this particular individual. This wasn't a professional fiduciary. This is a daughter looking out for her single mother. Next, 9, and I put a big asterisk about it. I put a common mistake of a trustee. Let that sit for a while. It's using a support trust to allow government benefits for beneficiaries. This will touch on third-party trusts, and it'll also touch on the program I mentioned at the beginning, supported living services. First, I'm just going to say the thing that I'm warning about at the beginning. Medicare, you don't plan having trust with a support trust knowing that someone's going to be a beneficiary in Medi-Cal. You don't plan that way necessarily. But the reality is the rules in the state of California are much more liberal than people think. If it's a third-party trust from someone not a spouse and not your own money, the assets generally are not counted. And there you go. For this case, it was an uncle who left the person money. But we have a wonderful man here who has cerebral palsy. Mind is very good, but really just can't move anything else. Actually, we got his mother on Medi-Cal. That was step 1. She was in a skilled nursing facility. Then he, who's lived all his life at home, was a risk because the money is running out. What do you do? Well, there's supported living services. He didn't even know about the regional center programs. So we had to do a hustle to get regional center to examine him, confirm he was disabled prior to age 18, prior to age 18. Sorry about that. 22 is a Social Security mark off. So prior to age 18, he was disabled. He continues to be disabled. eligible for regional center, eligible for the program supported living services, SLS. Oh, I've got my own caregiver. I've always had my own caregiver. What do? Agency hires that particular caregiver that you like. And it enables the person to be at home, which is fantastic, It saved the person. Just by even knowing a program, it saved the person. Now, not with him, but you could use this self-determination twist on regional center to really do some other interesting things. For him, I don't think it's appropriate at this time, but he just used supported living services. How did the trust come in? Well, long lost uncle left the money in a trust. Didn't count toward Medi-Cal, by the way. Didn't count for regional center benefits. And it turns out in this particular case, we really didn't want him to be on Medi-Cal for a variety of reasons, which I can go into, if there's time. Next, I'm going to mention just, I see their questions. So I'm going to mention on the last one, I am going to mention, by the way, the trust, I made a point here, the trust pays for the person's rent there. He used his own income, which he had some pension income from his father, who was a veteran, who was injured during the war. The trust supplemented his care at home. And there you go, regional center, the state of California is paying for 24/7 care for him, total. With it turns out the caregiver even he wanted for one of the shifts. Very long time. He's been doing well. Next, I'm just gonna on the last one because I want to have time. I see a bunch of questions here. I see a bunch of questions. Mine equal only. How do we access the outline? Terry keeps referencing. Oh, these are easy. But before I go on, it should be in the link. The outline Terry's referencing was emailed to you. Hi, Sonia. It's emailed to you, and it should be in a screen someplace. So the outline should be right there. Let me just get and I'm going to finish up, and then I'll go to. I'm going to finish up, and then I'll go on to other questions. But you should be able to see the outline in. Gosh, it should be in someplace in the materials. If maybe our bar technical folks, Sonia could email that to you, but it was also emailed out with the program. Let me go through the last example I have, and for this example, I think I just want to touch on a bunch of benefits all at once. It's using special needs trust wisely when there are special benefits. Here's some questions I would ask when I'm looking at the situation. Does this beneficiary have Section 8 or reside in affordable housing? That matters to me because the rules are different. You can't, you've got this problem from a trust paying reoccurring expenses for the person that can count toward income. And Section 8 or the affordable housing is an income only program. Was the beneficiary disabled prior to 626? Well, that's an important question in this particular case, because if that is the case, so if that's the answer, yes, then you could use a Cal-Able program, which is a beautiful way it's maybe one of the only ways for you to, one of the only ways as a trust to pay for something on an ongoing basis for someone who has affordable housing or Section 8 without it affecting the benefits. You pay to the Cal-Able program instead. And then the Cal-Able program pays for this reoccurring expense. Is there an opportunity for non-recurring assistance? I dealt with that already at the beginning, which is when I talked about this. The problem of Section 8 is if you have a reoccurring bill you're paying, it potentially counts toward income. Totally different benefit, calculation than Medi-Cal. And I see our nice folks at the bar say materials were emailed this morning. They're also visible here, so that you should see that up there. Sonia or anybody else that's missing the materials. Another question I asked for this particular case is the IHSS in-home supportive service provider at the same home as the other person. Sometimes, many times, you have people who are living together in a home. One person is the provider under the Medi-Cal's in-home supportive services program. The other person is the person who gets the services. There's a very nice niche, and that nice thing that anybody should tell. If you know anybody who has family member with a disability getting in-home supportive services, just please share this with them, that if they have the same primary residence, the in-home supportive services income that comes in to the person is federal and state tax-free. Very nice thing, very easy to share with somebody. And I think that may be it. I mean, I could talk about some other things that are here. I mean, I mentioned some other things just very quickly, and then I'm going to go to see about the questions. But very quickly, I just mentioned something in the number 10, the last example, is just so you're at least aware of it. You don't have to be, not going to be expert at it, but just you're aware of it. Okay, I mentioned the issue about the IHSS and taxes. Another interesting issue that I mentioned here that came up in this particular case was you're about to get a supplemental plan for your Medicare, but if you have Medi-Cal already, you're not supposed to get a supplemental plan. So really the time frame should be you get Medi-Cal first and then you get your supplemental plan, because if you're fiduciary for a beneficiary, let's say, and you really want the best for him or her, you want Medicare supplement and Medi-Cal maybe. So, but you're supposed to get the Medi-Cal first, or you can't sign up for the Medicare supplement. And also beautiful, I'm going to mention 3 more beautiful things that were in this example, and then I'm going to go to the questions, just so you know about them. A very interesting thing, and particularly when I said at the beginning that Medicare is becoming important, establishing a work record for someone that's on SSI can be very helpful, because while that person is working and getting just a minimum amount of money, that person's also developing his or her own work record. And when you get that for enough quarters, you get Social Security disability income, not just SSI. And you can, Social Security, SSI is a bit of a pain. But Social Security disability income is nicer. It's not asset-based, not passive income based. It is based on your work income. But if you can get that, and you can have your SSI recipient build up your own Social Security, so that they can, after 2 years of that Social Security, get on Medicare, that could be very beneficial for someone, particularly as, even with Obamacare and no pre-existing conditions, as so many insurance plans are going toward a mode that is really paying medical providers HMO rates. You'd rather have, if it's you, any of the 59 people listening, if it's your insurance and you want to go to a doctor, you want to pay the doctor well, and you want to pay a top doctor, you feel that way about yourself or anyone you love, then you'd much rather have the Cadillac, or I'll say the Tesla of payment, which is Medicare and a supplement. And you get Medi-Cal too, fine. That's for other things, long-term care. So that's a nice tool to get somebody on Medicare. By the way, the person get on Medicare too, if the person's disabled prior to age 22 and off the parent's work record, if the parent dies, becomes disabled, or retires. The final 2 little things here were nice. If you're going to be in an HMO, everybody's got their personal preferences, but many people like Kaiser. And so, but you can't just go, at least unless something changed just super recently. You say, I'm on Medi-Cal, I want to join Kaiser. The tool there, lots of tools, lots of quivers, is you pay privately for Kaiser, then you switch to Medi-Cal, and then they take you on Kaiser. It's a nice tool. And the final, I'm just going to mention one thing. It just happened on this particular, it was part of this particular case. And I'm going to get to the questions here, is IRA payout to avoid share of cost. IRAs, if you can imagine, you're taking money out of an IRA and you're an individual, you want Medi-Cal. A nice little tool to avoid the share of cost issue is what I do, and then I'm going to leave it and go to questions. Instead of just taking a distribution from an IRA, which just counts toward income, which increases your share of cost or deductible for Medi-Cal, you take the money, start a new IRA, and you cash out the IRA. Then that way, instead of that cashed out IRA, instead of that becoming income, it becomes just cash asset. And works well with this 130,000 business. You have 130, let's just use the example right now. You have a couple 100,000, 200 plus thousand in an IRA, not counted. Let's say you elect $25 distribution, you're under 45, or you're older and you've elected some distribution and you want some cash out of there. If you just take distributions, it's going to be income for you, and therefore it's going to increase your share of cost for Medi-Cal. Instead, now take $130,000, split it off from the IRA, new IRA, cash out the $130,000, presto changeo. You've got an IRA that came in for $130,000, no income counted. Okay, let's get to questions here for about 8 minutes. Okay, Chris, these asset limits apply online for Cal Medi-Cal. Yeah, Medi-Cal across the board. I mean, it's for all Medi-Cal except for the Obamacare Medi-Cal. So it's for what we call the traditional Medi-Cal. Does it impact Medicaid in other states? I don't know about other states. When this first was talked about, everybody's talking about it as we are the only state doing it. When I was talking to another attorney in New York, the person told me they were considering it, doing it. My guess is that we're the vanguard for this right now. And other states aren't doing it, but I don't know for sure. Okay, here we go. There's a more detailed one. Beneficiary is born with a developmental disability on SSDI, Medi-Cal, Medicare, took out life insurance policy years ago, has become severely disabled. Is the policy reachable? Okay, let's see what kind of benefits we're talking about. Medicare doesn't matter, right? Not asset-based. SSDI doesn't matter, not asset-based. Medi-Cal is the only one, plus if you said developmental disability, that means maybe the person's a regional center client. Regional center, assets, income are not supposed to count. They've tried to knock away at that a little bit, but still assets don't count. So the only one you could be talking about is Medi-Cal. Is it reachable for Medi-Cal? Life insurance policy, the cash value is countable as an asset. So assuming they have, they don't have Obamacare Medi-Cal because they have SSDI and Medicare. So they would have this traditional Medi-Cal. So you look at this life insurance policy, if the cash value and this person's other small bank account is 130,000 or less, you're good to go there, not counted as an asset. Reachable, meaning is there recovery? The key to avoid recovery is there should be a beneficiary named on that policy. Then you avoid recovery. If there's no beneficiary, you may have a problem. Okay, next. Okay, the same person, wait a minute. Beneficiary lives with family. Beneficiary lives with the family. Approved for IHSS, in-home supportive services. Residence not owned by beneficiary. Okay, I'll good to go. Our IHSS money is taxable if the caretaker hired is a family member who owns the residence. It's got to be the primary residence, not the. It's got to be the family member caregiver has to use that place as his primary or her primary residence. It's not good enough for the caregiver family member just to own this other home. So that's the answer to that question. Oh, and you're welcome. That was a thank you. And let me see if there are other questions or chats. Otherwise, I could, I could be talking about more things with this to fill up another 4 or 5 minutes. But first, I want to make sure anybody out there that wants to, that I'm missing under chat or any place that wants to do this. A minute. Maybe there's one more. 1 second. Oh, thank you very much. Okay. It looks like there are no questions. Last chance, and then I'll just I'll do it's really only a couple minutes, but I can do an impromptu sum up. Which is what I'm going to do. The benefit programs are they're a little complex, and as I mentioned at the beginning, for someone just to say, oh, let's do a special needs trust, third party special needs trust, first party special needs trust, so we can protect the assets. It's too simplistic. It's not doing the job for the people or the family. A lot of people don't get government benefits or need government benefits. And there are a lot of downsides to planning when you get government benefits. So on the one hand, there are many situations out there where people don't even know the benefits, like this wonderful man who I helped, who didn't even know. He was in his, I think, he came to me maybe in his early 60s. He never even availed himself of the regional center benefits, which kept him at home. And I've got other ones. I could think if there was another one right before that. Somebody, trustee, very experienced counsel. But when I told them, do this, this, and this, because you can get supported living services to pay for the caregiving. They were amazed, kind of, but they did it, and it worked out fine. So there are many times you don't even know about the programs. That's one situation. But on the other hand, there are many times when people are doing all sorts of things to get on Medi-Cal or another government benefit program, and maybe it's SSI, and it's just not appropriate. Medi-Cal doesn't help. I mean, I think of horror stories because I've come in before as an expert sometimes, not just as an attorney. When you get the contingency attorneys suing attorneys, and it's just not appropriate. Sometimes you don't really. Medi-Cal is not really the key goal, or government benefits not the key goal. But on the other hand, sometimes it's something that could really save you. So it just pays to look at it all very carefully. And thank you very much. I think we're to the end, unless there's another question. Nope. I think we're good. Okay. Thank you very much, everyone. See you next time.